Zoning ordinances regulate the use of land. For example, if a property is zoned for residential use, the owner can't build a factory on it. Therefore, owners sometimes need to have their property rezoned before they can develop it. Is it okay for a landowner to promise a town money in exchange for rezoning? We explore that question in the 2003 case, Durand versus IDC Bellingham. IDC owned a power plant in Bellingham, Massachusetts, and wanted to build a second plant in town. In 1997, IDC approached town officials about the possibility of rezoning the parcel of land where IDC wanted to build, also known as the locus. IDC learned that the town needed $8 million to build a new high school. IDC then offered to give the town $8 million as a gift if rezoning was approved and IDC was able to build and operate a power plant on the locus. The town held an open meeting and introduced a zoning article calling for rezoning of the locus. After discussion and comments, the zoning article was approved. Maurice Durand owned land near the locus. In 2001, 3 years after the zoning article was approved, Durand filed suit against the town, IDC, and several other defendants. Durand sought a declaratory judgment invalidating the rezoning because it constituted illegal contract zoning. The land court found that the rezoning didn't constitute illegal contract zoning. On its own motion, however, the court granted summary judgment to Durand. The land court found that IDC's $8 million offer constituted extraneous consideration, which was offensive to public policy. Accordingly, it concluded that the rezoning vote was invalid. The defendants appealed, and the matter was transferred to the Massachusetts Supreme Court.